Hi everybody, this is Kelsey. Signing in. Today is the 30th of December, 2014, a few days after Christmas. It was 9 days ago, December 21st, 1987, that would be 25 years ago, that I was first convicted, on this murder case that I'm talking to you about now, that I've been putting on the website. And again, I have no recourse. What am I supposed to do? 25 years of my life, about 12 years, 9 months inside of Illinois prisons, and then another 12 years outside, having to deal with marginalization, can't get the best jobs, having to work hard jobs. I remember when I first got out of prison, needed some money, had to go and do jobs like carry oak, wood, kitchen doors all the way down the stairs, and then taking them over to the dumpster and throwing them in the dumpster. You know, just hard back-breaking work. And all of this is a result of this conviction. I mean, I just can't sit here and just accept this. That is my only recourse. If anybody suggests, well, you're out of prison now, that's my recourse, is just to accept this and not say anything about it when the Constitution says that I can talk about it, that I can grieve, I can redress. Okay? I'm not bothering anybody. I'm simply getting on the website, voicing my innocence about this crime. You know, the Apostle Paul, my right to do this is founded and is rooted in the Bible. The Apostle Paul, as you know, had dual citizenship. The Apostle Paul wrote certain books of the Bible, as you know, in the New Testament. But the Apostle Paul was a Jew, but he was also a Roman citizen. And so he was being held basically in prison. He was in custody. And so finally he said, hey, I want to appeal to Caesar. I am a Roman citizen. I, Kelsey Wicks, I vote. I'm a citizen of the United States, and I have a right to redress, to grieve, to make grievance of my situations to the government. Paul appealed to Caesar. This is a constitutional matter I'm talking about. The brief that was filed in my case, and I can't file anything in prison anymore, I'm not in prison, were violation of what we allege were constitutional violations. My constitutional rights, for example, the Fourth Amendment. Kelsey Wicks was deprived of his Fourth Amendment right to be free from unreasonable searches and seizures. So, President Obama, you are the chief executive in this land that we live in America. If you had lived and had the same position back during the time that Paul was in prison, you would have been Caesar. So I'm appealing to you now. I'm appealing to Attorney General Eric Holder. Mr. Holder, you are the top attorney in this land. I have suffered an unjust conviction. I have documentation that I can send to you anytime you want to. I can scan it. I can email it to you. I can send it to you in the mail. I can make copies. Okay? So, I'm just, to say that I'm angry, I think I have a right to be angry if I'm innocent, and I am. Okay? I have here a hematology report. This is about the victims. Hematology, I'm not a doctor, a medical doctor, but it deals with the issue of blood. And this document here, okay, that I can send to you anytime you want to, Mr. Holder, Attorney General, I can send this to you. A medical doctor looked at this document years ago and told me, Kelsey, he said, the times that you're talking about, that allegedly occurred with this victim and so forth, the time she was found at 5:55 a.m., that much is pretty much is not alleged. That's what the security guard at the hospital said. So that's pretty much correct, okay? But the alleged times in this statement or alleged confession, this interlude allegedly between myself and this victim never occurred, okay? I wanted to get out of there. Here at 10:30, 11 o'clock, the detectives testified that we got to the police station in the morning, and here it is now 10:30 at night and so forth. I wanted to get out of there. What am I have to do? How many days, how many hours do I have to sit there to get out of there? Their report says that I denied any knowledge of this incident. That's what their report says. Okay? Denied any knowledge of the incident, and there was nothing to link me to the victim. This is the state's report. This is the police report. How much longer am I supposed to stay there? Constantly denying this. I don't know anything to talk about this lady. The police testified earlier that he told me I'm looking at this police report now. Okay. So, at page 26, you told, the question was put to the detective who was on the stand. Now, you told him the woman was the subject of a severe beating, correct? I believe so, yes, was his answer. And you told him you wanted to talk to him about this at the station. Okay, even though that's the detective's testimony. But you have to understand, I don't know who this person is, what occurred. Perhaps he did tell me that. I really don't recall, okay? But I know when they came in that afternoon and threw a picture of someone in this picture with bandages wrapped around the head, appeared as they were laying down. I could not tell if this victim was. They didn't offer any. They didn't offer any information about the gender of the person. And this is probably like 2, 3 o'clock, maybe something like that. It's been a long time ago, but I'll say something like that. And I was just stunned. I was just like, you know what? I don't know, but I could not tell the gender of the person then that was in that photograph. So what happens is now for someone to come along now and take a bit or a piece, I'm talking about now a jigsaw puzzle that leads to a trail. And to take a piece of that jigsaw puzzle out and say, hey, look, I thought that is not the context. You have to view the context of this from the time that I was accosted by the detectives in the vestibule of my apartment and the time that these alleged statements were made. Confession, okay, was made. An alleged confession was made. That's the time, and you have to put all the pieces together to get the full view of and the context of how this event, this occurrence, produced this statement. Okay, produced the alleged statement. That's what you have to look at. You can't take one piece out of a jigsaw puzzle and say, hey, this, that, and that. Okay? That's not going to happen. So, the hematology report by this doctor told me, this report here that I just showed you, said that Kelsey, that victim, the injuries, the blood concerning this victim indicates that happened much earlier. Okay? Not around the time 55 and then a few minutes before you all had some type of altercation and you drove it to her and all that. No, none of that happened. Somebody found her, and these two people that said something that they should not have known. The detective, the security guard, hospital security guard, said that he was looking. His trial testimony on the stand was that when he uncovered the blanket over the victim, he was looking directly at it and thought it was a black male. These two people said something. In legal terms, I think they call it an excited utterance. They said something that was so unusual, okay, that also can be an issue that you can raise, an excited utterance. But they, according to this police report, they told the security guard that a woman was laying outside in the bushes and there was a green blanket pulled over her head, something that they should not have known. Okay? Now, the hematology report and this other report from the hospital says that corroborates, because it says now that the victim was cold and pale. okay, cold and pale. This is at 5/4/87, the day she was found, and the time on this document is 6:15, and they said they found her at 5:55 a.m. So we're talking about a 20-minute differential. However, this report could have been written later, okay? But what it does say is the victim was cold and pale, which corroborates what the doctor told me about this hematology report, that this attack on this woman, this altercation, whatever it was that she suffered, how it was, okay, happened earlier than the times alleged in the confession. That's the whole point, okay? There's also Dr. Smith. We didn't get a chance to talk to Dr. Smith, remember? The state produced a witness, a pathologist, who basically said that in two instances, that the alleged jump rope handles, that the statement or confession basically states was used to assault the victim was not likely. And then he also said that he didn't think it caused any of the injuries suffered. Not likely, not it. I think it said, and then it's not likely. Okay. So we're talking about now evidence. It's more than just statements and words. The corroboration, cold and pale. Okay. Incident, according to the hematology report, occurred. The loss of the blood, okay, indicates that this occurrence happened sometime earlier, okay, much earlier than the time alleged in the confession. And don't forget, there are things that I know about this case that you don't know, and they fit together right like a jigsaw puzzle. They fit right together, okay? And also, a newspaper, and don't forget about the ultimatum. There's cutting-edge technology that we have available nowadays. If there are photos of that victim's body that shows bite marks on her, one says a bite mark, another says a possible bite mark, all of my teeth are still the same since 1987. I might have lost a jaw tooth, okay? But all of my fronts, all of these are still the same. Anytime you want me, day or night, come and get me. I'll bite down on something. That's an ultimatum. I'm not guilty. I don't have any problems doing that. Okay? There's cutting-edge technology that was not available to me. Okay? In 1987, probably. That can enhance or corroborate what I'm saying. Would my dental prints have be found anywhere on that victim? Okay? Also, the attorney who called, now in 1987, okay, a few years, let's go a few years more. In prison, I recall reading about a confession of a case and the ruling handed down by the United States Supreme Court that basically said, to say that a lawyer called you at the station and you didn't get a chance to speak to him and they denied you the right to speak to him is not enough to overturn a confession. Okay? Basically, it says something like that. And now in 1987, that ruling hadn't come down yet. The precedent that was still, or the controlling law at that time was still that if a lawyer called down to speak to you, and especially if he showed up, they could not deny you access. The police down at the station could not deny you. So in 1987, that was still applicable to me. That law was still controlling. Okay? Also, a newspaper guy, a newspaper friend of mine, who had done some research on this case, testified at my trial. He testified. Why would a newspaper man testify at my trial? Let me read you the trial testimony here. Got it right here. The judge is saying, call your next witness. Do you want to raise your right hand, sir? The witness is sworn in. And they state his name. He's called as a witness on behalf of the people of the defense. my attorney speaking now. He's called as a defense for me. Being first duly sworn and was examined and testified as follows. Direct examination. You may sit down, sir, talking to the newspaper man. Would you state your name for the record? The witness states his name. Would you like to spell that for us, for the court reporter and the state? He spells his name. Mr. Blank, what is your business occupation? I publish a community newspaper. What is the name of that community newspaper? And then he gives the name. How long have you been publishing that paper? About 6 years. And what community or communities does that newspaper serve? And he basically gives the areas that his paper is circulated in. Okay? So, and at one point he had indicated in court that he had planned to publish a story. Okay, but at that time, for whatever reason, he didn't get it done. But the reason he was going to publish the story is because he knows about things that, what I'm telling you that I know about, and you don't. He knows some of the same things. Why would the newspaper man testify on my behalf? There must have been something that encouraged him, that he felt that the court should know, and the jury, pertaining to my innocence. He was a witness for me, and he's still alive. He's still around. Why would that? So all of this now, hematology report, 2 people saying things that they perhaps indicates that perhaps we never got a chance to talk to them. They never testified at trial. Okay, Dr. Smith, one of the treating doctors who first saw the victim when she came in, when they found her. We didn't get a chance to talk to him. My attorney didn't like that. We wanted a chance to examine him. Newspaper man, getting ready to testify in court about what he knew about this trial. Okay? And so, all of these things. Then there's issues about, and then there's also legal issues that we're raising now. Was I in custody? Was I not in custody? Okay? Because there's 2 different testified that you guys, there's lawyers out there that can tell you this is the testimony. When I was down at the station, one of the detectives on the stand. Okay? And then it took about another, about another 20 minutes to return. Yes. So we're talking about they had left the station and the detectives and they come back. So that's the conversation. And so, okay. And so that's the conversation. And so he's asking the detective. So the detective is saying that it took about 20 minutes to return. Yes. So we're talking about roughly an hour, a period thereabouts. Yes. Somewhere in that area. Yes. In which Mr. Wicks was left in this room at the police station he's talking about. Correct. When he was left in that room, was the door shut? Yes. He could not leave the room? I guess not. No. This is the whole point that my attorney is arguing on appeal, going up to the court. Okay? The appellate court judges, my attorney is saying, look, he was in custody. The detective is testifying here that he could not leave the room? No. Okay? The door locked from the outside? I assume it does. Yes, that was the detective's answer. Mr. Wicks was not free to go at that point if he had asked, the detective says. My question to you, my attorney says, was when you left him in that room with that door locked, Mr. Wicks was not free to leave that room when he was there, was he? The detective says, no. I assert to you that's custody. That's an arrest. And if that was an arrest, that is my attorney's point here. Okay? Where he was arrested without probable cause and where the statement, which was a direct result of that illegal arrest, was the instant. And my attorney is saying, were it not for him being held down at the station, this statement here would not be admissible in court. It would be fruits of the poisonous tree, quote unquote, something like that. Okay. So So that's the whole thing. So that's kind of like what I'm talking about right now is I think it's wrong for anybody to think that I just have to accept this 25 years of my life, 12 years and 9 months that's been taken away from me and put in Illinois prisons, and another 12 years out here living on the edge, having to travel way out to find jobs that don't hardly pay anything. Because if I went right down the street right now, if I go down to the State of Illinois building, they took the question out of applications when you file an application for a job with the state. They don't ask if you are a convicted felon. But right across the street from the State of Illinois building in Chicago, Illinois, downtown, there's the City of Chicago, and then there's the Cook County building. And the last time I checked last year, and it still might be that way, they do ask that question. So I can't apply for any of those jobs. Excuse me. So I'm going to go ahead and close, but I'm just saying, there's physical evidence that does not corroborate, in addition to the pathologist's testimony, the state's witness, that the injuries found on the victim were not likely to have been caused by the jump rope handles as stated, as written down in the alleged confession. Okay, so that's what's going on there. Then the hematology reports does not corroborate the blood, victim's blood and the amount and so forth. The hematology report, not a medical doctor. The medical doctor does not corroborate. I can send all of these documents to you, Mr. Holder, okay? You're the Attorney General. I can send all of these. I can send a copy of the brief, okay? One detective testifies that I was not in custody. Another detective testifies that the door was locked behind me and I could not leave. Okay? So, I'm going to go ahead and sign off. But as the Apostle Paul in the Bible had a right to appeal to Caesar, these are constitutional, there is at least one constitutional issue. We actually cited more than that. But, so this deals with federal. This is a constitutional issue, and this is why as Paul did, I'm making an appeal to the President and to Eric Holder on this case. I did not kill this victim. Thank you very much. Bye-bye. Signing off.